Sethi. And Your Honor, I would like to reserve 5 minutes for rebuttal. Please.
Very good, Mr. House. One question, I might as well ask you both. There is a cross appeal. So the question I have really directed to the other side. Are you going to argue everything in your answer, or do you anticipate wanting to reserve any time to rebut on the cross appeal?
Please, the court, Your Honor, we would prefer to argue everything all at once if the court is so inclined.
All right, so you will have your initial argument. Go ahead and address whatever you wish to as far as the cross appeal as well, or you can argue that in your reply or your rebuttal time, and then you'll just have your 20-minute for your argument after he finishes his initial. Does that sound good?
Yes, Your Honor.
All right, thank you.
So it'll be 15 and then I can save 5.
5. If you want to, because of the cross appeal, if you want to reserve a little bit more than 5, you may do so. So I'll leave that up to you. But you know, the cross appeal I think is fairly focused on what the issue is.
Thank you. Your Honors, thank you for this opportunity for oral argument. My client and I very much appreciate it. Mr. Sandeep Sethi, the appellant, is the owner of the property in Chapel Pines development. Now, he became owner first in November of 2017 by virtue of a certificate of title that was given to him by the clerk of court as a result of his purchase at a foreclosure sale by the association. So the association had a pending case going back prior to 2014. They got an amended final judgment in 2014. The case sat there for a while, apparently because of the prior owner's bankruptcy issues and so forth. The HOA set the sale date back in September for October of 2017, had the sale, did not ask for more fees at the time. So there was an award of attorney's fees in that HOA foreclosure judgment. My client was the winning bidder, paid the entire judgment amount plus a surplus of about $7,000. My client also purchased the same property again at a senior foreclosure sale in 2019. I call that the Wilmington senior foreclosure sale in the briefs. Your Honor, 5 years ago, more than 5 years ago, we had an initial hearing on a motion to dismiss where my client raised the declaration. The declaration is a contract that is not to be impaired by a statute. It's a constitutional issue if that is the case. At that hearing before Judge Sestak, which then retired, my client, through me, raised the declaration as an issue in the motion to dismiss based upon count 2 for damages. In count 2, in the complaint, they being the HOA, sought all the prior owners' assessments, attorney's fees, interest, and costs against Mr. Sethi. Now, that was wrong according to the declaration, and I raised it. And in the brief is noted, it's in the transcript from that August 2018 hearing. Opposing counsel for the HOA said you can raise that defense later in an answer, which we did. Your Honor, this is a 2001 declaration, which has some clear terms. Liability shall not pass to a successor owner. So the liability of Mr. Lutzker.
Maybe I can short circuit this a little bit, because ultimately they conceded that they weren't entitled to it, or they waived it, depending on how you want to interpret it. But ultimately they did not ask at the final call of this case. They did not ask for those amounts.
Yes, thank you, Your Honor, for pointing that out. And that is a big issue because essentially they made a seismic shift, a case shift in their whole position. In November of 2017, before the ink dried on my client's certificate of title, the HOA through its counsel sent a demand for $10,000 plus $9,000, I believe, of which was attorney's fees. Yes, they did concede it at the summary judgment hearing in June of 2020. The whole reason why we were there at that point is because we had the defenses and said, you can't do that. It wasn't until the actual hearing that they conceded. And the court accepted that concession. But in essence, that's the Augustine case. They were using the Augustine case, saying that there was a confession of judgment by my client. A confession of judgment in the Augustine case talks about paying what was pleaded. What was pleaded in the amended complaint was all the prior owners, 2014, 2015, 2016. So in essence, they conceded that there should be a judgment for SETI on that defense. This case, Your Honor, and nobody wants to be here 5 years later, but the fact is we had a summary judgment where we had defenses raised all throughout the proceeding. They didn't meet their burden. They eventually
Most of
conceded.
your defenses were related to the foreclosure though, correct?
No, Your Honor, it was
Well,
related.
I read the defenses, the first 3 or 4 specifically say defense as to the foreclosure. And that's not the wording, but it talks very specifically about in the foreclosure. Let me see if I can find it real quick because I made some notes about that because I was concerned about that. So the first one, given that foreclosures are matters of equity, it would be inequitable. Paragraph 29, plaintiff is stopped from seeking foreclosure on an alleged lien. Paragraph 30 is stopped from foreclosure. 31, anticipatory breach, that is not limited to the foreclosure.
Okay.
32, improperly rejected, that's not limited to the foreclosure. And the same with, I think, 33 and 34. So it looks like the first 3 or 4 are foreclosure defenses.
Yes, Your Honor, that's fair to say, correct.
Okay.
I'm sorry. Yes, 4, 5, and 6, I believe, are those that I'm really referring to, the defenses to the damages count. Because later on in this matter, there was the Wilmington foreclosure, which was a senior foreclosure, and by virtue of the sale, the lien was extinguished as a matter of law. So
the lien would have been extinguished as to anything the prior owner that might have been claimed arising out of the prior owner's ownership. It would not extinguish the foreclosure to the extent that your client had not timely paid an assessment, correct?
the foreclosure would, by the second one, the senior foreclosure would take away, in essence, the HOA's claim for assessments up to that foreclosure, most of which was the prior owners.
I'm not sure I understand that. Why would that eliminate their ability to foreclose your client's interest if he owed money to them?
Well, the main argument, Your Honor, is that it foreclosed out up to the certificate of sale / title, which came 10 days later when the sale was confirmed by no objections. But just by the language in that Wilmington judgment, which I believe is
I mean, everybody conceded, so I don't want to spend a lot of time on this. Everybody conceded that the foreclosure by Wilmington mooted out the foreclosure in count one.
Yes.
Okay.
Your Honor, the declaration was clear, not to pass to successor. Owner fell when it matters who the owner was when the assessment fell due. And lastly, it was an annual assessment. So the 2017 assessment was an annual assessment. And who was the owner at that time? Glenn Lutzker. Now, the HOA has made one reference to a prorated, that somehow was prorated and somehow that we paid it out of good faith equals a confession to judgment. First of all, Your Honor, that prorated language has to do with when there's a first sale of a lot. So that back in 2001, there were many lots and not all the lots sell at the same time. The prorated language, which is only mentioned once, shows up in the first lot provision, first sale of the lot provision.
Your client didn't dispute its willingness to pay those that last half of the 2017 October assessment. I mean, he ultimately tendered it, went into trust, and I don't think that was ever really litigated, was it?
Your Honor, my client did pay the prorated portion of that last one. But we've always argued that that was done in good faith and that if anything,
But your
it's-
client was still late on the January assessment and the April assessment, correct?
it was not paid. But it wasn't like my client refused to pay.
I understand your client got a letter from them saying you owe more than that, so we're not accepting your payment.
Correct. Don't
But
pay.
either way, he didn't tender payment
Correct.
until it was late.
Correct. Correct. So for those two, January of 2018 and then April of
Is
2018.
there anything in the record to explain that point? And it was just something that had me scratching my head, like, why not tender the payment? And just say, I am hereby tendering, and the association refuses it, they refuse it, and then the chips fall where they fall. But then you've got a tender payment for the amount that ultimately was what was owed. Is there anything in the record that explains why that didn't happen?
Well, my client did tender in May 2018, $187.50. They got it, said they're not going to take it unless they apply it to the hierarchy, which is interest in their attorney's fees first. And so when they contacted me, because I was counsel for Mr. Sethi at the time, I made a good faith letter in June of 2018, right before the SESTAC hearing, the motion to dismiss, where I asked specifically, that's in the record. We want to know what's the interest, what's the attorney's fees, what's the cost, and if there's any administrative late fees attributable to Sethi's ownership. Crickets, nothing, no response. It was eventually sent back for 187. So we did try to pay, my client, I should say, try to pay those that according.
In May, but in May was when that
Correct,
occurred.
correct. And here's the thing, we had already done a motion to dismiss, or we had a motion to dismiss. They had already told us anticipatory in a breach manner saying, don't send us anything.
Yeah, that also kind of raises a question I had, which is, I'll speak candid, I don't understand your anticipatory breach argument.
Okay.
To my mind, it seems like if the association is failing to follow the scheme of 720-3085 sub 3B, then that is simply, it is a failure to do what you're supposed to do under the statute. I can't conceive of how that works. An anticipatory breach, which usually in breach contract actions means you are excused from further performance. So help me out, help me understand.
Thank you.
How that works.
Thank you. So what I'm saying is we're not arguing that SETI should be excused from paying any assessments. We're saying we shouldn't have to pay what they demanded and said that they wouldn't take anything less. And
So
if
that's just a denial.
no, I think it's more than a defense because they're saying we're not going to live up to the declaration. We're going to demand things that the declaration says shall not pass.
It was pled the way it was pled.
Okay.
I had a hard time understanding
No,
that.
did I answer that decently?
I think.
Okay.
It sounds more like you're just denying that the way they wanted to apportion fees was correct. And that issue probably could have just been teed up.
Well, that's a good point here. It's also not just anticipatory breach, but a misuse of 720-3085. They're saying we must apply anything you pay first to interest, then to attorney's fees. So my client,
Well, I'm not sure that's incorrect, actually. I think what may be incorrect is the effort to apply it to the prior owners. debt.
right,
But it doesn't seem, as I read the statute and the declaration, it doesn't seem to be incorrect that if they had focused solely on what your client owed, that they're going to apply it first to past the attorney's fees, interest, late charges, and then the amount on the assessment.
correct. And that would be the misuse. We understand that if there was a late payment, it should be applied to interest first and then to attorney's fees. So it's the misuse. They're saying we must take it and
Again,
apply
it's the
it.
question as to what does your client owe?
Correct, correct. Your Honor, the summary judgment, which really is the foundation of this whole matter, is the July 2020 judgment. We have a de novo standard of review for that. And in this case, your honors, the HOA did not meet its burden. They submitted one affidavit, which talked about October 2017 in their ledger being attributable to Mr. Lutzker. So that whole prorated portion that Mike's client sent in good faith essentially should be applied to interest or whatever that may have accrued, which I then asked for back in June of 2018 for that amount. Your Honor, what happened was my client filed affidavits, raised the defenses. Their affidavit says nothing about the defenses, talks about it being, the money is being applied. And the real kicker is that all these trust payments were assessment payments into trust magically by the preparation of the court order, turn those into payments to mere interest and attorney's fees that had to be later. So my client for the past 5 years has been religiously sending in assessment payments, which have been still held in trust. By the way that the judgment is worded, all that money up to the time of the judgment, and I don't know where the money is currently for all those other ones.
Well, it's been reduced to a judgment, so it doesn't appear that that matters anymore. If we were to affirm that is done.
Correct. Your Honor, so really what happened, Your Honors, what really happened is the trial court took a side, chose sides, and thereafter kept on choosing the side of the HOA. Yes,
Mr. Hufford, you're at your 15-minute mark.
okay,
I'm going to give you an extra minute or two just in case you want to address the cross appeal.
sure. So the cross appeal, actually, I need to go into the attorney's fees. Just
So you
on
can use,
the
you can use
manager.
those couple of minutes however you wish.
I'm sorry, thank you. Attorney's fees. So, Your Honor, Your Honors, they did not meet their burden as the movement for fees. They have to have detailed copious notes. They also have an obligation to prune under cases such as Blanton. In this case, at the day of the evidentiary hearing in September of 2021, they made a maneuver of doing what's called color-coded fees.
Demonstrative, they use the demonstrative basically, right?
No, actually,
To say, we actually are going to go after these fees, we're not going to go after these fees.
yes, but it was after the hearing. I didn't see the highlight until after.
Can
Correct.
you tell me, what is the total amount, like dollars and cents that you believe got overpaid, like that should not have been awarded? What is the final amount? 'Cause this is your issue on appeal, you have the burden of.
Right.
To show us this.
Your Honor, I whatever the number is between the lien being extinguished and at most the November
What's
2020.
the amount?
I don't have that calculated, but that's the range that should be followed through November 2020, because we were
That
at,
puts us in kind of a weird position where you're basically asking us three to put on a green eye shade and act as your accountant to go through this and figure this out and deduct, you know. I guess you're saying whatever the court's discretion feels is deductible, but usually on an appeal where you're the appellant, where you're saying that the trial court worked too much money, that's your burden to lay out for us. These fees, these entries, this amount, these hours need to be reduced for these reasons. And it's hard for, at least speaking for myself, it's hard to work with a range.
I understand, Your Honor. Now, at the hearing, we did have an expert, Matt Wolf, which went through many, and the court actually struck a lot of that was not intertwined. And my concern was that even when we got a small victory, which was no fees on fees, the court then awarded fees for fees. And so that's why, Your Honor, I apologize. I don't have a number. Personally, I think my client should be considered the prevailing party because he understands the $150 issue but that's what we've always tried to pay. In fact, he tried to pay $187.50. And we get a seismic shift at the judgment hearing. So frankly, and I don't mean this to be rude, Your Honor, but my client should be awarded fees. But if they're going to be, they should at least be.
Mr. Ross, I've let you go over if you're
Okay.
going to reserve your 5 now.
Okay. Thank you.
And for the appellee, you'll have 23 minutes to argue if you need that.
May it please the court. My name is Jason Davis and I represent the appellee cross appellant in this matter, Chapel Pines Homeowners Association, in the appeal of 3 separate orders to this court, a separate consolidated case in this number. 2 of them deal with the final summary judgment entered in this matter, February 24th, 2021, a separate order, February 24th, 2021, denying Mr. Sethi's request for judgment on count 1 of the lien. And then the final order is the fee judgment for the attorney fees and costs awarded to Chapel Pines.
Mr. Davis, the first thing I'd like you to address, what was the basis of the association's claim that it could seek from Mr. Sethi any monies owed by the prior owner?
Your Honor, and I think you hit on this, was the in rem amounts that the association could seek. In Chapel Pines,
How could they seek after the foreclosure against the prior owner any money from the new owner?
an
Didn't it
interesting,
merge into the final judgment of foreclosure against the first owner?
it did not, Your Honor. The judgment of foreclosure against the first owner had a delineated date that included the assessment amount, interest, attorney's fees
So you
through that date.
You could have sought modification on that, right?
I believe there was some talk that you could seek an amendment to the final judgment. I take a different view that you cannot amend a final judgment after a certain time period. It has to be appealed if there's an error in it. I know that there has been a practice where,
So if your client felt that the prior owner was uncollectible, would it be entitled and allowed to narrow the amount it claimed from the prior owner and reserve to go after that amount against the successor owner?
so I believe that the association is entitled to proceed against both owners on an in rem basis. Again,
Give me authority for that, because I didn't really see anything in your brief that justified what the association demanded from Mr. Sethi.
yes, Your Honor. I think the problem, and you're likely not, I don't recall it being in the brief because that's not the judgment we're on appeal on. We're here on the personal damages.
We're here on an appeal involving a claim against Mr. Sethi that seems to me to be significantly overstated at the beginning of the case.
Yes, sir.
You sought fees against Mr. Sethi that were the responsibility of the prior owner because that foreclosure against the prior owner, and you didn't pursue all of those fees. You asked for assessments that were the responsibility of the prior owner that would have merged into the final judgment of foreclosure, and you could have pursued him for those damages, but your client chose not to. So I want the authority that tells me what your client did at the inception of this case was correct.
Your Honor, I don't believe that we agreed that a merger occurs, but what I would say is we sought, or Chapel Pines sought, the amounts owed against the lot, not against the individuals
And you
themselves.
foreclosed against the lot, against the prior owner.
Chapel Pines did foreclose against the prior owner. Mr. Sethi took title November 15th,
And
2017.
so at the time he acquired title, he paid for that through the certificate of sale at the foreclosure. So what authority is there to demand from him monies that were the responsibility of the prior owner?
Under the declaration, I believe you have 2 different avenues of relief. Your personal obligation, both owners have their,
Counsel, I understand what an in rem and an in personam claim, what those 2 claims are. What is the authority under the declaration that the monies that could have been claimed against the prior owner somehow go to the purchaser at a foreclosure sale?
the monies under the declaration that are assessed against the lot is what the association shot. And again,
And that was foreclosed.
that was foreclosed up to a point, Your Honor.
So in other words, you're just saying, because we foreclosed a limited amount, we can still attribute to the next owner and pursue a foreclosure against the next owner, money that was owed by the prior owner.
Unpaid monies that were assessed against the lot, not necessarily the owner. Yes, Your Honor, I believe that's the position
So
we took.
the first foreclosure means what? You just get rid of that owner and you can, you know, if you were able to foreclose Mr. Sethi, then any money he owed you would now say, whoever buys it, be aware, you're going to pay for it.
Whoever buys the lot has a choice. And typically what happens in the foreclosure, Your Honor, is they will request a payoff indicating what's the amount owed on the lot itself. And we don't disagree that there is a demarcation line in the documents that say personal liability shall not pass to subsequent owners unless expressly assumed by them. But you're given a choice when you purchase from a foreclosure sale of the association. There are additional amounts that could potentially be accruing after your judgment is entered.
And
That's
so
for-
if there's a surplus at the foreclosure sale, your client's not obligated to go after the surplus. It can continue going after the property owned by the purchaser at the foreclosure sale.
I believe the surplus proceeds is pretty clear, only available to cover any junior lien holders. The association couldn't say, hey, I've got excess amounts. After the final judgment is awarded, these surplus proceeds should be applied to those additional
You can't
amounts.
go after the surplus, but you can maintain a lien on the property for those. How does that work?
The lien itself is based on each individual assessment. So every time a quarterly assessment in this case came due, the lot itself is lienable. And I think Judge Silverman, you pointed this out. Even in Mr. Sethi's case, we could lien for the amounts that were not foreclosed that he.
So you could choose, if you have an uncollectible owner who has filed bankruptcy, you could choose to limit the amount you claim in the foreclosure as to that owner, hoping that the successor purchaser is going to be collectible.
I think you limit it in the sense of your questioning to
Is
the
there
amount
any
that
case that supports what you're arguing?
I don't have one offhand, Your Honor. That was not the argument of the brief, and I
Why don't you-
apologize.
Why don't you move on? Because, well, I don't know, maybe my colleagues are persuaded, but I think I know where I stand on this issue, and I'm not convinced, absent some authority that you can point to, that the foreclosure doesn't eliminate the debt owed by the prior owner as to the lot, that the foreclosure leaves it open to whoever buys the lot down the road, and they're going to be on the hook.
Your Honor, I apologize if I'm not answering your question that you're putting forth, but I think
I
the issue,
understand your-
There may not be an answer to it.
I don't have the answer off
Well,
the
I
cuff.
understand the theory. I just don't see anything in the law that says you're right. And you haven't suggested that there is anything in the law or the declaration that says you're right on this theory, that the foreclosure does not wipe out the debt owed by the prior owner.
And I think, again, I may be, retreading the ground on this, but I think it's the difference between what is owed on the lot and what's owed individually. The lot's lien is each individual assessment, and each individual assessment that was unpaid, even after a foreclosure judgment, still liens the lot or is lienable by the lot if you take the appropriate statutory steps to lien it, which Chapel Pines did in this case. But focusing back on what we're here on today, that's not the issue that was presented to this court. As the court noted, a foreclosure occurred by the mortgage holder, which wiped out any in rem liability prior to that foreclosure date, except for the personal liability owed under the declaration for Mr. Sethi. And that's solely the issue the association proceeded under, which led to this February 24th, 2021 final judgment. It's what is the amount owed by Mr. Sethi? And if there are delinquent amounts, the declaration provides for interest, provides for attorney's fees and costs. How do we get to those amounts? To establish those amounts, the association submitted its renewed motion for summary judgment for only the assessments owed by Mr. Sethi from that half quarterly payment when he took title on November 15th, 2017, the January 2018 payment, and the April 2018 payment. Those payments were found by the court, no dispute, even admitted by Mr. Sethi.
Didn't the affidavit, though, have some entries for early 2017?
The affidavit had entries for 2017 because it was still the same amounts that were assessed. The assessment amounts did not change. And we were only moving forward on that delineated mark of the portion of the October 2017 assessment, January and April. That was the only amounts we claimed. I believe the trial court specifically asked counsel at that time, Ms. Io.
But the affidavit that your client submitted had additional amounts, correct?
It did, Your Honor, and it had a running ledger that associations keep property ledgers that show the amounts that are assessed against the property. And there was no dispute that the assessments are what they are. And under a breach of obligation payment, all the association needed to show was, is the amount of assessment in dispute? The answer to that was no. Did you account for all of the payments? The answer to that was yes, we did. We had an affidavit of Mr. Haas on behalf of his client. Judge Sestek, instead of granting a receivership order, issued an order that counsel was to take payments from his client, keep them in trust until the conclusion of the case, to be applied to any amounts found delinquent. Judge Compton received the payments, canceled checks, the affidavit of Mr. Sethi accounting for all of the payments that Mr. Sethi had made. And there's no dispute that those payments were ordered by the trial court to be applied according to statute 720-3085 sub 3B. And that, I think, is where the problem is. Mr. Sethi, on behalf of his client, is arguing, I believe, that the court should consider any payments made after those 3 assessments to be current. And that's not how the statute is set up. That was the basis of the letter, I believe, that has been referred to, that counsel for the association indicated, look, there's a statute, the statutory payment hierarchy requires us to apply it in this manner, first to interest, late fees, attorney fees, costs, and then to the delinquent assessment. Any attempt to designate or authorize only the application of your payment in a different manner, it can't be done. And I believe there was sufficient argument in front of the trial court where the trial court decided, by including that specific fact in its judgment, that the amounts paid during the course of the case would be applied by statute upon determining the last 2 pieces needed, which was the attorney fees and costs to the association. And Your Honor, I know there was some talk about the July 2020 summary judgment, but again, I want to focus this court that we're not here on the lien foreclosure matter. We're here solely on what's owed personally for Mr. Sethi that led to the judgment on appeal, that February 2021 judgment, just indicating what his personal judgment is. On that judgment, I believe the court received sufficient, conclusive, undisputed summary judgment evidence to support its findings as to the principal amounts owed. Again, assessments owed by Mr. Sethi personally. The second issue appealed, the attorney's fees and costs. I believe my colleague touched briefly on that, but the court conducted a laborious 3 days of evidentiary hearings on this matter. We received testimony from an attorney from the association's counsel's office, received in the timesheets from the association's counsel office, went line by line on the last day of the evidentiary hearing to delineate which fees it would be awarding, which fees it would not be awarding, and the reason why. Transcripts of all 3 hearings are part of this record, cited by both parties in their briefs. The court received evidence from both an expert witness for the association, expert witness for Mr. Sethi, considered all that evidence and came up with the number of 76,000 and some change, reducing it pretty significantly from what was requested by the association. So there was no error by
The association initially requested over 100,000, if I remember, and then it reduced it to 80-something thousand, and then the court reduced it further.
a significant amount based on the court's instructions. Again, over 100,000. Yes, Judge Silverman, that portions of it related to the lien foreclosure case itself, and the court indicated in an order that there was no prevailing party on that count 1 lien foreclosure case. Only the association was prevailing party on the count 2 money damages claim. And that dovetails into our cross appeal issue.
Did the trial court make any findings as to the affirmative defenses raised by Mr. Sethi?
The trial court did not make any findings in its summary judgment order as to the affirmative defenses. That being said, the defenses, as Your Honor pointed out, I believe the first 3 or 4 related to equitable claims as to the lien. Those no longer applied with a money damages claim. Judge Lucas, I believe, pointed out the anticipatory breach is in reality just a payment defense. It is you're misapplying the payments. We deny that you are applying it correctly according to statute. which I believe that's just a legal issue on it. And the rest of it is some various form of payment. When you've received these payments, you've rejected them, and that's simply not the case as reflected in the trial court's order. All the payment, the full amount, are to be applied per statute. There's no dispute that I paid more or less than what the trial court found. And there's no dispute that the statute controls the application of the payment, notwithstanding a non-final order by Judge Sestek that instead of a receiver, counsel was to keep future payments in trust pending the conclusion of the case. And so moving to the cross appeal, if I have no further questions on the original
I have
judgment.
one other question as to the attorney's fees, the row factors that are in there. One of them has to do with the value of the claim versus the amount of fees and reasonableness. Was that argued to the trial court?
It was argued to the trial court as far as the experts opined on each of the row factors, including, Your Honor, the factor you mentioned. And certainly it is for the amount of the principal a large fee award, but the fact that this case began in 2017 and was heavily litigated by both sides of the case to get to this point, each step of the way, I mean, you can see a 3-day evidentiary hearing on attorney's fees, even that portion of the case was heavily litigated to get to the amount that's on appeal today. So this wasn't, I think, a situation where the trial court didn't take into view the entirety of the litigation, considered the row factors, considered what it had the opportunity to perceive throughout the case, and reduce accordingly. And I believe the amount the trial court found under the row factors should be affirmed by this court, with the exception that the cross appellant, Chapel Pines, filed 2 issues for this court that we believe requires a remand for those specific issues only. Number one, that the trial court did not consider the work on the lien foreclosure count, a majority of those entries, to be inextricably intertwined. And the trial court made a specific finding in its order for the fees that found that the work on count 1 and count 2 were for the same common core facts, the same issue, money owed by Mr. Sethi to the association. That was the underlying facts that the association had to prove, both its lien foreclosure count and its money damages count. The entries which related to count 1, the trial court did not award, even though it made that finding that there was inextricably intertwined common core facts available for the association.
Doesn't that cut against you though? I mean, the fact that count 1 goes by the wayside because it just needed to go by the wayside. Wouldn't that just tend, like, you're putting a lot of emphasis, you're putting the bullseye on that, but it seems to me that Mr. Sethi is the prevailing party on that.
So I would disagree, Your Honor, to the fact that what was the issue that we were there on? The issue wasn't.
Well, the issue the homeowner association was there on was to get this relatively small amount of an assessment paid and its attorney's fees. And ultimately, hopefully from the homeowner association's view, it gets that secured by a piece of property because you're more likely to be able to collect that relatively large amount of money from a piece of property rather than a personal judgment against the individual. If you look at it from that point of view, you all came out way behind in this.
And I think that if in any aspect, when you have these types of small assessments and you have a heavily litigated case, that can certainly look like a lopsided balance. But
well, no, listen, you see that in PIP, you see that in a lot of different cases. You see that in construction liens sometimes, you know, like a $2,000 construction lien, $100,000 of attorney's fees. I mean, that happens. I'm saying though, in terms of you didn't get a lien. You lost on that issue, which is where all of the security is for you all to get all those fees.
we did not have the ability to foreclose a lien. That is correct, Judge Lucas, and we did not have that ability.
You brought that count.
We did, Your Honor. We did not have that ability solely based on not a
So having
defense.
lost that, why is it an abuse of discretion that the court found that there was no prevailing party as to count 1, but a prevailing party as to count 2? When the thrust of the whole action is count 1.
Well, I think the pleading included 2 counts, Judge, and it was for both the lien and the money damages count. And again, it's just to recover money. That was what the payment was. And Mr. Sethi owed money to the association, and that's the remedy the association can
The
seek.
reason count 1 is count 1, right?
Correct, Your Honor. Lien foreclosure is count 1 in almost all typical association foreclosure cases.
I meant that figuratively. It's the money one. It's the big one. You really don't want a personal judgment against these. I mean, you'll take it because that's all you were left with. What you want is the lien on the real property. You can then foreclose and get all your fees.
Yes, Your Honor, with the security
Okay.
interest that you have, yes.
Okay.
But it wasn't a defense that led to the mooting of the account, and that's what the trial court found. It was a senior mortgage holder's foreclosure of the association's lien.
Which got bought out, just so happens by Mr. Sethi.
It did, Your Honor, and
Yeah.
that's, I think, where the argument Mr. Sethi made at the trial court level was, because I bought out the senior mortgage foreclosure, I shouldn't owe this amount. And that's simply not the case. There is still a personal amount that he owed at the time he took title to the case, even if we can't foreclose on those amounts because it's been wiped out by the senior mortgage. So the work, though, to get to that original summary judgment, which was awarded by the trial court on the lien foreclosure prior to being mooted, dealt with determining what the amounts are for the lien itself. It's work that had to be replicated at the same time we went for a money damages count. And so the association argued to the trial court, and the trial court disagreed, that it was inextricably intertwined. And that's the fees that we believe this court should remand to the trial court to determine what the reasonable amount is. If this court finds that it is inextricably intertwined work on both counts, you can't recover on a lien and a money damages at the same time. Recovery on one forecloses literally the recovery on the other. The second issue on cross appeal is it's a fees for fees argument, and that's simply a de novo review by this court of the language of the declaration. We've cited to you the Waverly case out of the fourth trial practices out of this court. The Palma, State Farm v. Palma's case has indicated general rule, no fees for litigating the amount of fees. That's the rule in Florida, with the exception of if a statute provides broad enough coverage, or if the contract, in this case, the declaration provides broad enough coverage. It's a reading of the declaration's provisions. The trial court determined in its order that it did not view the declaration's award or fee shifting provisions, as sufficiently broad to award fees for fees. Chapel Pines believes that the fee provisions, which, and I believe the quote is, and the cost of collection thereof, including without limitation, court costs and reasonable attorney's fees, legal assistance fees before trial, at trial, on appeal, shall be a charge and continuing lien on the lot and the personal obligation of the owner. And then further down, there shall be added the amount of the assessments, aforesaid interest, late charges, collection costs, attorneys and paralegal fees and collection costs shall be recoverable, whether or not suit be brought. So the cases that have viewed contract language, and it's been language that includes any or all. On the trial practices case, it was a consulting agreement which included very broad language. We believe this is on par with that language that allows for an amount of fees for litigating the fee award on appeal with this court. And that's the second issue on cross appeal. We'd ask this court to remand to the trial court. Again, a number has not been determined. The trial court simply found that the contract language was not broad enough. We believe that was error. We'd ask this court to remand to the trial court with the specific instructions to determine what, if any, fees were reasonable for that litigation period. And if there's no questions from the court on either the judgment or the fee judgment or the cross appeal, I would tender the rest of my time.
You must have an internal clock that works really well because you just ran out of your time. So thank you.
Thank you, Your Honor.
Mr. Hunt.
Thank you, Presiding Judge. Could I try to answer a question that
Of course.
Your Honor, Honorable Lucas asked about a number of fees? And on page 48 of our brief, I actually tried to answer a similar question, which was the best and most competent and reliable evidence for the amount of time that the association spent by the time we tendered that payment back in June of 2018. The documents reveal an attorney fee total between $643.79 and $943.79 that could have been taxable to SETI if the association had simply answered the request. That's page 48, and we list the documents we cite to the record. We got those numbers looking at three documents. The demand letter of November 2017. If you look at the breakdown, then we look at the claim of lien, and then we
But
look at
that's,
the payoff.
that's the position you're asserting that, look, if they had just gotten back to me,
Correct.
that's the amount they would have
Correct.
spent.
So
I'm not.
it's not really
sure that-
answering
Yeah,
your question about the evidentiary hearing.
I hear what you're saying.
Thank you, Your Honor.
Mr. House, I have one question as to the dropping or the mooting out of the foreclosure claim. Am I recalling correctly that you and opposing counsel agreed to the trial court that there was no prevailing party as to that count?
I wish we would have agreed, but here's what happened. On November 2020, when we had this fee experts there ready on Zoom to go, that's when the circuit court said, wait, you got to decide on, was there a winner as to count one? And the court basically, the trial court basically said, we're going to have a hearing. So the association did their motion asking for all those fees. I did a motion separately, which said we should get the fees as prevailing party, but I specifically put in there, but if not, there is discretion of the court to say no. So I cited to a case of McKenzie. And so I should say at the hearing in February 2021, they quickly conceded it was moot. And I'm like, well, it has been moot. And so why have you asked for fees beyond November 2020? That's why I was answering Judge Lucas's question. That's where it should stop, because we were right there with expert fees. And even the association has later said that, this is their words, it's difficult to understand what remained after July 2020. The February 2021 did not tread new ground. Well, they moved for judgment as to count one. They wanted to be prevailing party. That's when the court, when they acknowledged at the February 2021 hearing that it's moot. Of course, I'm not going to argue with that because at least they're not getting their fees, but I still made the argument by motion at the hearing as well that Your Honor should consider us the prevailing party. But if not, I think it was the McKenzie case that said the court could say, because it's moot, no prevailing party, which is what
You have
happens.
about a minute and a half left, so why don't you say whatever else you want to.
Sure. The color coded, there's no mention in their cross appeal of the color coded maneuver they made after the first evidentiary hearing. The first two of three were all their presentation of the case. Your Honor, I want to dispel the notion that Pudlett was an in rem case. That was the argument that the HO made, even in its briefs. And that's what the trial court believed, that it dealt with count one, not count two. In fact, Pudlett mentioned personal liability several times, personal obligation several times. Not once does it mention in rem. The Coral Lakes case of the second DCA is just like Pudlett. Your Honor, going back to the cross appeal, they did drop, and they should not get a second bite at the apple. I found a case of Booth v. Booth recently, which also talks about no second bite at the apple. They dropped it, and I cite all those references on page 22 in the record. They're not seeking anything that's not highlighted. Is there anything else the judge asked? No was the answer. We're not seeking. Your Honor, the $11,770 in the cross appeal closing argument is not evidence. When they refer to it in their briefs, they're referring to closing argument. And secondly, no documents, nothing was reviewed as to the 11,770, and there's no time entries that could be evaluated by the court or my expert. They're saying they want it now after they already told the court, no, we're not seeking.
And Mr. House, that brings us to the end of your time.
Thank you.
Thank you both for the presentation today.
Thank you.
And that concludes this case.
Thank you.
Our next case is Mercantonio versus Gertis. I hope I pronounced that somewhat correctly. Thanks, Council.